Hello everyone, welcome to Yadhu Study Hub. My name is Sushma and today we'll be understanding the term complaint, section 2 clause D of the crpc 1973. So we do complain about so many things in our day-to-day life, but what is complaint according to the criminal procedure code, that we'll be understanding today. And in code, what amounts to complaint and what does not amount to complaint, that will be understanding. So don't forget to watch this video in whole so that you will be understanding you'll get an exact picture of complaint. So let us understand the definition part. Complaint means any allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offence but does not include a police report. So the definition itself postulates that there should be allegation in relation to some person, known or unknown, having committed an offence, and then only the allegation would be covered in the ambit of the word complainant. So suppose if the allegation submitted before the court does not disclose any offence whatsoever, then the same would not be covered within the definition of the complaint as defined in section 2 clause D of the code. So in any case, whether the document submitted to the magistrate is a police report or whether it is a complaint, has nothing to do with the power, authority or jurisdiction of the magistrate to take cognizance of the alleged offence. Then section 190 of the code provides three sources from which a magistrate may take cognizance of an offence. So even if termed as a charge sheet, the documents forwarded to the magistrate in that regard amounts to a complaint, and the magistrate would be competent to take cognizance of the alleged offence on that basis. Now let us understand the explanation part. So under this subsection, that means a police report made by a police officer in a case which discloses after investigation the commission of non-cognizable offence shall be deemed to be a complaint, and the police officer by whom such report is made shall be deemed to be the complainant. So under this subsection, it says that explanation report of the police officer after investigation disclosing commission of non-cognizable offence. So non-cognizable offence means where a police officer has no authority to arrest without warrant. Example is giving false evidence, cheating. So if you want to understand what is cognizable and non-cognizable offence, then check my video. I have explained it in detail. It will be helpful for you and for your exams. And now coming back, disclosing the commission of non-cognizable offence is to be deemed to be complaint, and the police officer who submitted the report has to be deemed to be a complainant. That means a charge sheet submitted by the police in a non-cognizable offence shall be treated to be a complaint, and the procedure prescribed for hearing a complaint case shall be applicable to that case. The case law that we'll be referring is Danveer versus State of UP. The Allahabad High Court has laid down that material brought on record, it transpires that the charge sheet submitted by the investigating officer instead of being treated as a complaint has been taken cognizance of by the concerned magistrate as a state case, which is not permissible by law. So now we have understood the definition part. Now let us understand the instances of complaint. So what are complaints? The example is where A charged B with housebreaking. B lodged an information against A for theft of his gun. But the police reported B's case to be false, whereupon B filed a petition of objection asking the accused held that the petition of objection filed by B was the complaint. The next example is a petition of a complainant who has withdrawn his case and again asked to be allowed to proceed with the same. The other one is the presentation of a petition by the complainant that his complaint should be inquired into. The another example is a letter to the magistrate conveying the information of an offence and asking the magistrate to take an action. The next example, a petition addressed to a magistrate containing an allegation that an offence has been committed and ending with a prayer that the culprits will be suitably dealt with. The another example is, suppose there is a protest petition is treated as a complaint provided it satisfies the requirement of this clause. When the complainant files a petition before the magistrate for including some persons in the list of the accused whose names were not sent by the police to the magistrate, showing them as accused in the charge sheet, such petition can also be treated as complaint by the magistrate. The another example is the complaint made to the sarpanch. When forwarded to the magistrate by the sarpanch with a report to take cognizance, amounts to a complaint, even though the original complaint was not made to the magistrate. The other example is, police report is a complaint within the meaning of section 7 clause B of the Dowry Prohibition Act 1961. The another one is a complaint filed by the Assistant Collector of Customs on behalf of Union of India is a complaint, even if there is no valid letter of authority from Union of India. The next and the last example is where a magistrate sent a report to the district magistrate that some person has made an alteration in a document filed in his court and has committed an offence under section 477 of the IPC, held that the report amount to a complaint. So now we have got an idea about what is complaint, what amounts to a complaint. Now let us understand what are not complaints. First one, statement made in deposition. That means statement to be used as evidence. Second one, an application for issue of process, a petition containing no prayer for magistrates taking action does not amount to complaint. The another important example is a complaint made to a police officer is not complaint. The another one is a petition for maintenance under section 125. And the another one example is a petition sent to magistrate by a husband against his wife for recovery of jewels alleged to have been stolen by her. So a petition making certain charges against a person and asking for an order to the police to warn that person in the first instance, even that is not a complaint. So the another one is a letter to the commissioner of police to take action for removal of a cow from his compound and for arranging for his safety and security and for that of the members of his family. Even that does not amount to complaint. So what is the value of complaint? To lodge complaint is not to give evidence upon which a court can act. The complaint is in the nature of an indictment. Therefore, the averments in a complaint must be established and properly proved by the evidence. So in general, a complaint into an offence can be filed by anyone excepting in cases of offences relating to marriage, defamation and offences mentioned under section 195 to 197. So any person who set the criminal law into motion by making a complaint before a magistrate against the accused is the complainant. So who can file complaint? The complaint made by a registered partnership firm is maintainable since it is covered by the definition of a person as given in section 11 of the IPC. And the another one is complaint can be filed by a member of a company for offence under IPC committed by any person with reference to or in relation to the company. Complaint filed in the name of Union of India represented by a particular public servant, collector of customs without letter of authority from the former is a valid complaint. So it is not necessary under this clause or under section 190 clause 8 that person lodging a complaint must have personal knowledge of the facts constituting the offence. In a case like this, it is reasonable that the court, before issuing summons, should satisfy itself upon proper materials that a case has been made out for issuing summons. So this section does not prescribe that complaint should be presented in person by the complainant to the magistrate, and that it may not be posted to him, or that it is posted, it is not a complaint at all. Thus, a telegram can amount to complaint in view of the fact that the definition of a complaint includes an allegation made in writing and does not in itself necessitate the presence of the complaint. So, a complaint by MLA in criminal court against persons deployed by the speaker to maintain law and order in the assembly is not maintainable. So in today's class, we understood what is complaint and what is not complaint. So if you like my video, like and subscribe to my channel. Don't forget to click on the notification button so that whenever I post a new video, you'll be updated. Thank you.